Hello, everyone. I'm so glad you're here. Today, we are all about life and legacy planning, and the topic is how to keep your family out of court and conflict. A serious topic, but seriously, one of the most important topics that we could consider. My name is Holly Simpson, and I am a wife, a mother to 6 children, a grandmother to 3, a sister, an aunt, a daughter, a friend, a colleague, and most importantly, an estate planning attorney. And I'm just honored to be able to spend this time with you today. In order for you to get the most out of our time together, I would really suggest you just take this time that you deserve for yourself. Turn off your phones, close your doors, shut down any applications running in the back of your computer, and maybe get a pen and paper so you can write down any questions you have. And at the end, I will tell you how you can get those questions all answered for free. Now, before we get started, I'd like to acknowledge that some of you might already have an estate plan in place, and that is great. You may still have some questions here today. You are maybe here to learn about what happens when I move. Is my will still valid? Or is my will that I got done on freewills.com, is it going to work for me when I need it to work? You're in the right place. We're here to answer all those questions today. If you don't have an estate plan in place, you're also in the right place. Approximately 62% of Americans don't have an estate plan in place yet, and that number is even higher for people who have families with young children. So you are absolutely in the right place. And we're also going to have some people on here that might be wondering, am I in the right place? I think I'm too busy to get my will done. I'm too young. Is it going to cost too much money? And we're going to address all of those things in our presentation today. Now, we have a lot of clients who come to us and they're afraid about talking about estate planning. It's not the most pleasant topic, death and dying. And one of the big fears we often hear about is that if I talk about estate planning or if I get my estate plan done, it's going to hasten the occurrence of my early demise. And I just want to reassure you, we've created thousands of plans for families and found absolutely no correlation between those who get their estate plan done and those who don't get their estate plan done and whether that hastens their demise. So you're in the right place. A lot of people also have a fear that it's going to take too long. It might be too costly. I'm not old enough. I'm not wealthy enough. I have some good news. We will make this as easy as possible for you. We'll be very upfront with all our information, and we try to create a process that people actually enjoy getting their estate plan done here at Simpson Law Firm. Now, you are absolutely in the right place if you've ever thought about any of these things that we've just discussed, and especially you're in the right place if you've got loved ones, family, friends, nieces, charities that you really care about and that you want to make sure that those organizations, those people are provided for and protected in the case that something happens to you. The reality is we don't do estate planning for ourselves. I didn't create an estate plan for me. I created it, of course, to protect my large family and those that I love with. And it's not you who will know if your estate plan works when you pass away, but it's the people that you love. And if you leave behind a mess, they're the ones that are going to know that your estate plan wasn't done well, or you didn't bother to create one, and that you lived up to your promise, that you took care of this very important thing for your family. Now, what you're going to learn today is from a couple of perspectives from our family called the Bliss family. And you're going to learn about what happened to them when they had a estate plan in place, so the after, and what happens to this same family before they actually got their documents in place. Now, you're also going to learn all the details, everything you need to know about how to get started working with us, how long it'll take, how much it costs, and don't forget at the end, there's also going to be a bonus where you can learn how you can get all that information for free. Now, before we jump into the Bliss family, I want to introduce you to my real family. And you can see there's my 6 children. We've got one of the grandkids in the picture. Need to update this picture with a couple more marriages that have happened, a couple more grandbabies. And you can see I have a large family, and so family is very important to me. And maybe you can identify with this if you're a parent, but our house was full of chaos and fun all mixed together. And so, of course, you know that I consider my family to be my greatest asset. Now, I went to law school while I had 6 kids, which is unique about me. I loved law school, and I was a little bit later in life, I used to practice as a divorce and marriage counselor. And then I went back to law school and loved every minute of it. I was the only person in my law school graduating class to have a cheering section of 6 children. And they were my greatest supporters. I was actually able to graduate as a valedictorian in my class. And I hate to admit that I did not have an estate plan in place for my own large family until after I became an estate lawyer. So you are in the right place if you're worried about getting judged about procrastinating or putting this off. There's none of that going on here. Another big why about why I love estate planning and why I think it's so important is the story of my own grandfather. My own grandfather, he was an entrepreneur before being an entrepreneur was cool. He had all sorts of little jobs. He did everything from sheep raising to he had a dairy farm for a while. He did a little handyman business. He had a little taco store. So he had a lot of little things, bought some land, had some little things going here and there and everywhere. Super do-it-yourself guy. He actually did pay for someone to create a trust for him. However, as is common, the trust was created, but it wasn't properly funded, meaning he either didn't take the time or the lawyer didn't take the time to explain to him that the assets, you can't just create a trust, you actually need to put the assets inside of the trust. To complicate things further, our family had an aunt who had special needs, and so my grandfather had meant to provide for her in a long-term trust. That wasn't set up or funded correctly, and it ended up creating a lot of conflict and chaos in the family. So the aunt with special needs thought she was entitled to more than maybe my grandfather would have otherwise wanted her to get all at once. He wanted her distributions to be doled out over time instead of her getting a lump sum all at once. It caused some real hard feelings in the family. In fact, they ended up having to hire some attorneys to unwind the mess, and also a corporate trustee to end up taking care of the money for my aunt too, because there was so much conflict going on in the family. So I thought to myself, as I started learning about estate law, I thought, surely that must be malpractice, that someone set up and charged my grandpa pretty good money to create a trust, and then no one ever funded it, and the special needs trust wasn't done correctly. But unfortunately, I found out it's more common practice. It's very common practice for estate lawyers to set up the trust and then wish the family well on their way doing the funding on their own. And I knew when I started my own firm that we could do things different, and we could ensure that people's trusts are funded correctly so that their plans actually work for them in the time when they need them. Now, a little bit more about me. After graduating from law school, I worked for a couple of other estate planning firms, and then I opened my own firm back in 2018. And since that time, we've experienced tremendous growth. We actually have 5 attorneys now that work for Simpson Law, and we have a very large support staff, larger than other estate firms in town, because we want to make sure that if you call, your needs are taken care of quickly, and you've got someone who answers the phone with a friendly voice that can answer your questions. You're not stuck waiting for an attorney to call you back. So we have a staff of about 16, so about 21 of us all together. We have 2 locations here. We've got our Fort Mill office, and then we also just opened an office there in Ballantyne. It's on the border of Ballantyne, Indian Land, to serve population over there in Charlotte and Indian Land. Now, I want you to think for a minute and maybe even write this down. Who is it that you're here for today? Who is it that needs your protection? You know, my case, it's probably my 6 children, my grandchildren. Now, I want to introduce you to our family called the Bliss family. They're not a real family, but we have Mark and Molly. They're married, and then they have Rebecca. And Rebecca is actually Molly's daughter from her first marriage. And then together, Mark and Molly have Sarah and Caroline. And the Bliss family, as we mentioned, Molly has an ex, and his name is Xavier. And Molly and Xavier, they met in college. They had a great time in college. They had a lot of fun. And unfortunately, Xavier never grew up. He continued that party lifestyle. And so things didn't work out with Xavier and Molly, but they had Rebecca together. They got a divorce. Molly got custody of Rebecca. Xavier came and visited, and he did do something right. He actually got an insurance policy, and he took out a $1 million policy, and he named Rebecca, his daughter, who's now 15, as the beneficiary of that life insurance policy. Now, Molly, in the divorce, she also got the vacation home. So she got their beach house there in North Carolina. The Bliss family, they love to go visit a couple times a year. They have a lot of fun there. They're just your average, everyday family. But the Bliss family, unfortunately, they're going to have some sad days ahead in our story. And our sad day number 1 is Xavier, Molly's ex. He turns 40, and he decides to go skydiving to celebrate. But unfortunately, skydiving gone bad, and he doesn't survive the fall. But remember, he did have life insurance, which is the great thing that he did, and it's $1 million, and he had named Rebecca, the minor daughter, as the beneficiary. So Rebecca, she's pretty happy about this. She thinks she's getting $1 million. She's a teenage millionaire, and she's starting to dream of the red fancy sports car she's going to buy. But unfortunately, because she's under 18, she can't get the money directly. And so that money's going to have to be held for her until she turns 18. And then at 18, then she can buy the fancy red sports car, which I think you can start to see some of the issues with this problem. So in order to sort out who's going to take care of that money from Rebecca, welcome to the probate court. They're going to show up at probate court. And of course, Molly is the mother. She thinks that she is the right one to be in charge of the money for her daughter. She is the mother. She will do what's best for Rebecca. She'll make sure that that money gets used for her. But guess who else shows up? So Xavier had a brother, and Xavier's brother's name is Zachary. And Zachary thinks I should be the one in charge of the money for my niece Rebecca. My brother, Xavier, would not want his ex-wife in charge of that money, and I will do what's best. So they both show up to probate court. They both hired lawyers. Molly hired us. Zachary hired his own attorney. Each of them are into it about $7,000. There's going to be some background reports, credit checks, item fees, and a court hearing. And question for you is, who do you think the judge is going to pick? Is it going to be Molly or is it going to be Zachary? And the answer is, we don't know. It's going to be up to the judge. It's completely within the probate court judge's discretion who he or she thinks is going to do the best job taking care of that money for Rebecca. It's not the ideal situation. So let's do something better for the Bliss family. Idea number one with this insurance policy. Maybe Xavier could have named Zachary as the beneficiary of this insurance policy. Okay, that's a bad idea though, and I'm going to tell you why. Because if Zachary is the beneficiary of that policy, he is the owner of the $1 million. He's the legal owner, and he is not required to use that money for Rebecca. And maybe Zachary's a good guy, and he probably would use that money to take care of Rebecca, but Zachary might have a spouse that's in his ear about what they should use the money for. Zachary might have creditors that could come after that $1 million. Zachary's on creditors, and if Zachary got divorced, that $1 million is subject to the divorce proceedings, so his ex-spouse could get half of that money. So not the best idea. Okay, another idea to avoid court is Xavier signs a will that says I leave everything to Rebecca. If she's under 21, I put Zachary in charge. Okay, but what Xavier doesn't know is that a will doesn't control all of your assets. So although this is maybe a little bit better idea, if the asset already has a beneficiary, like a will did, or there's joint ownership of an asset, the will doesn't control. So for example, we have three kinds of assets. There's kind of three buckets of assets. One is jointly owned assets. So this might be a house that has maybe Xavier and his new wife's name on it. This could be an account, maybe Xavier and a new wife. So even though in Xavier's will, he said everything he wants everything to go to his daughter, Rebecca. If the asset was jointly titled, it wouldn't go through the will at all. It would just automatically pass to the other person that's on the account or the other joint owner on the house. Then the assets with the beneficiary designations. So if he has the life insurance policy and he still named Rebecca as the beneficiary in the life insurance policy, the life insurance policy wouldn't go through the will. So even though he said his brother should be in charge of the money for Rebecca, because he just had a will and he didn't have a trust, we got the same problem. We're back at the probate court. We're back with the judge trying to decide who should take care of the money for Rebecca. Now, the third class of assets are the ones that would go through the will. So those are only the assets that maybe don't have a beneficiary designation or are not a jointly owned asset. So if Xavier had any accounts that just had his name on it, or maybe a car that just had his name on it, those are the kind of assets that would run through the will. So a will wouldn't even affect some of those types of assets. Now, one big myth we hear a lot is that if you have a will, you don't have to go through the process of probate. And probate is the process of getting the assets that were in your name. After your death, those assets need to be retitled to a different name. So there's a great reason for the probate court. It gets a lot of bad rap, but it's an important function we have here in society. And this important function, because it's a government function, it's costly and it takes a lot of time. And so those are the things people don't like about probate. Is it generally takes, here in the Carolinas, some bit of time between 9 months to 2 years to probate someone's estate. And there's a lot of cost involved with that, which we'll talk about later. Now, idea number 3 is Xavier could establish a trust that says, I leave everything to Rebecca if she's under 21 and I put Zachary in charge. This is a great idea. What is a trust? A trust is a will substitute. So it's a way for you to say who you want to get your assets, but it doesn't have to go through the probate court. Now, I like to think of a trust like a red wagon. This is one of the biggest questions we often get is, what is a trust? How does it work? It's kind of a complicated topic sometimes. So if you think of a trust like a red wagon, like the one you had when you were a kid, and inside the trust, you can put different kinds of assets. So you see the toys in our red wagon. So you can put your toys in there. You put your house in there. You can put accounts in there. The trust can also be a beneficiary, like of life insurance policies. Now, during your life, you've created the trust. You've retitled assets so that your trust owns them, so they're in the trust or in your wagon, and you are generally the driver of your wagon, meaning you're the trustee, so you're in charge of everything in that wagon. So during your life, you can pull assets in and out of the wagon as you drive it along. Now, upon your passing, in the trust document, you have said who drives the wagon after you are deceased. So you pick a loved one, someone you really trust that's going to drive the wagon. And by drive the wagon, meaning they get to follow your explicit instructions that you left in the trust for which assets come out of the trust and at what time. So if you have children, for example, maybe you're saying, they get half the assets when they're 25, they get half the assets when they turn the age of 30. And in the meantime, the trustee is going to be in charge of those assets until the children reach those certain ages. Now, the important thing about a trust is that it does not go through probate. And that is because a red wagon is not a human, right? To say that a trust is not a human, it's a legal entity. So the probate court only cares about assets that belong to humans. So when you die, they need to change the title. Because the trust owns your asset, it doesn't have to go through probate. So the person who's driving the wagon is the one that distributes the assets out of the trust. Now, you'll see conflict ensues when you have assets that you did not put inside your trust or inside your wagon, much like the story of my grandfather. He had assets, they were not titled in the trust, so they did end up going through the probate court, even though he had the trust. If he had titled his assets into the name of the trust, there wouldn't have been as many attorneys and court involvement. Now, you must fund your trust, and we talked about the different types of assets. There was the 3 buckets, the jointly owned, the beneficiary designation. All of those assets can go inside of the trust. Instead of being jointly owned, your assets would be owned by the trust. Instead of an individual being the beneficiary of a life insurance policy, the trust could have been a beneficiary policy. That way, upon Xavier's death, if he had named the trust to be the beneficiary of his life insurance policy, he could have named his brother to be in charge of that policy. He could have said at what ages Rebecca gets the money, and that money would have been protected from both Rebecca's creditors and from Xavier's brother Zachary's creditors and his future spouse he had. So lesson number 1 for the Bliss family: a review of your assets must be a part of your estate planning conversation. If you just have a document alone, whether it be a trust or a will, it's not enough to protect you, and it won't ensure that your assets make it to the people you want in the way that you want them to receive them. Okay, unfortunately, our Bliss family has sad day ahead number 2. But it's going to start out fun because they go skiing, and they're going to go up here to Sugar Mountain. Of course, I talk about skiing because I'm from out west, and I love skiing here. So they're going to Sugar Mountain. They're having a great day. They actually brought along their family friend, Dina. And Dina doesn't have any kids, but she's their neighbor. They do a lot with Dina. She's like a second aunt to the kids. Everybody loves Dina. They're having a great time until, unfortunately, a fog descended on the mountain, and then Mark and Molly collided, and they got some really serious injuries. In fact, they're unconscious, and they have to be life flighted down to Charlotte. And Dina's there with the kids. The kids are okay. Dina's okay. Dina calls Molly's sister, Mindy, and says, quick, we need you. There's been an emergency. Mindy tries as quick as she can. She's out in Texas. She needs to catch a flight. I don't know how long it's going to take her. It might take a couple of days. So who can take care of the kids? So Dina's there. The kids know Dina. They love Dina. That's who Mark and Molly would have wanted to be taking care of the kids till Mindy could get there. But Dina is not related to the kids. And unfortunately, in North and South Carolina, if you are not a blood relative or adopted relative of the children, you do not have the legal authority to take care of those kids. So even though Dina's there, ready, willing, that's who the kids want to go to, it's foreseeable that until Mindy could get there, that the kids would go into some type of government care until Mindy, a blood relative, could get there. Now, there is something better we can do for the Bliss family so the kids are not in this situation. And that is something called a short-term guardianship form. So if you don't have a short-term guardianship form, then only blood relatives can take care of the kids. If you have a short-term guardianship form, which I have to be honest, about 90% of estate plans done for kids with minor children are missing this form. If you don't have that form, then Dina can't take care of the kids. If you have the form, then Mark and Molly, they can designate on there a couple of people with backup. So they could say Dina and Mindy and another neighbor have the legal authority to take care of my kids if I'm incapacitated. Now, sometimes you're thinking, oh, that's fine. I named guardians in my will. So I named someone in my will who can take care of my children. The trouble with that plan is that a will only is effective after you pass away. So in this case, Mark and Molly, they're alive, but they're incapacitated, and they need someone to take care of their children. And the only way to do that, where you choose those people for yourself, is through that short-term guardianship form without having to go to the probate court to let the probate court decide. Now, importantly, if you have those short-term guardianship forms, make sure you give copies to your loved ones so that when they show up to take care of your kids, they've got a form that they can show the authorities, and the authorities can honor that form and let them take care of your children as you would like them to be taken care of. So lesson number 2, if you have guardians named in your will, that is great, but don't forget the important document called a short-term guardian form, where you name someone who can take care of your kids, meaning they could be their legal guardians, make healthcare decisions, school decisions for them in the case of your incapacity. Oh no, so there's sad day number 3. Molly's injuries linger, and she is still incapacitated, so she's still unconscious. And Mark's at the hospital, and as her spouse, he's making healthcare decisions for her. But Mindy calls, and she's on her way. She's a lovely but a little bit meddlesome sister and knows a little bit about medical stuff as well. But the doctors won't talk to her because of HIPAA. The doctor cannot tell her anything about her own sister's care. So Mark is trying to make all these decisions. Mark doesn't know if Molly wants to be kept on life support. He doesn't know what kind of life-prolonging measures. He's very stressed. He's got Mindy yelling at him. He's got a lot on his plate. Plus, Mark has a lot of bills piling up. So Mark is healthy. I forgot to mention that on our sad day number 3. Mark's healthy now. But he has money and accounts that he can't access because these accounts are in Molly's name only. So remember, they got married. This is second marriage. Molly had some assets. She left some of her accounts in her own name, which is fine. And Mark can't get to those. Maybe her 401k, some savings accounts, and he needs this money to start paying the bills because neither of them have been able to work for a while. Now, even though Mark is Molly's spouse, he cannot get to these accounts because she's still alive and his name is not on the account. So solution, welcome back to the probate court. Another probate proceeding so Mark can get access to her accounts. The probate judge may decide that Mark is the appropriate person to get to her accounts. He may decide it's Mindy. Back to the probate court to decide who will make the medical decisions because Mark and Mindy can't seem to get along and decide what's best in Molly's best interest for her healthcare decisions. And again, they've each got lawyers, they're each $5-10 grand into this. Expensive. So better plan for the Bliss family, of course, would be for Molly coming to our office prior to going skiing so that Mark can make the calls. He can make all the healthcare decisions needed. Mindy can still give him input, but at the end of the day, maybe he still has the final say. Mark also can have Mindy helping because maybe she does know a few things. And if Molly decided Mindy could talk to the doctors but not make healthcare decisions, she could give her a HIPAA release so she could talk to the doctors. Mark could also pay all the bills because he would have been named a power of attorney. So Molly would have created a power of attorney document. Mark would have all the legal permission he needed to access any of the accounts and use the money for Molly's best interest. So lesson number 3, for our Bliss family is the only person other than you who can make your decisions if you haven't done them in your estate planning documents is a probate judge, and you don't want to let that happen. Okay, sad day number 4, Molly passes away. And unfortunately, remember, she didn't have documents, so who's going to be Rebecca's guardian? Mark will be the guardian of their 2 biological children because he's the surviving parent, but Rebecca, her dad, Xavier, if you remember, passed away. So Mark, of course, is the stepdad. He loves his stepdaughter. He wants to be the guardian of his stepdaughter, who he considers his own daughter. She'd be with her sister. She'd be in her same school. He seems like a really good choice. But unfortunately, Alexandra, she is the grandmother of Rebecca, and Alexandra is Xavier's mom. And Alexandra worries she doesn't have that good of a relationship with Mark, and she thinks if Mark had full custody of Rebecca, that she would never get to see her granddaughter again. So even though she's a little bit worried about her age and being able to take care of a teenage girl, she really feels like she needs to go in and fight for custody as well of Rebecca. And unfortunately, we go back to the probate court. And because Rebecca is 15 years old, she also is part of this process. So that means she's testifying in court. She's talking to guardian ad litem. She's aware that there's a disagreement between her grandmother and her stepdad over where she should live. It's stress that no mother or parent wants to see their own child go through. And also, we don't know who the judge is going to choose at the end of the day. Is it going to be a blood relative, or is it going to be the stepdad? We don't know. The judge is going to take all the factors, limited information that they have, and try to make the best decision they can with what they've been given. But at the end of the day, we don't know who the judge will choose. Now, also remember, Molly's passed away, and she had a beach house. It was part of the divorce settlement from Xavier. And although it used to be fun, now the family has a couple of problems because Molly passed away in the state of South Carolina. So Mark is going to have to open a probate estate in the state of South Carolina for all of her assets in South Carolina. But remember, the beach house was actually in North Carolina. So double probate, meaning he's going to have to open a probate estate in the state of North Carolina, and they're going to have one simultaneously running in South Carolina. And you can imagine more probate, more problems. Also, we haven't even talked about the IRS. When someone passes away, of course, the IRS gets their cut first. And before we go into more about the IRS, I have a question for you. You may have heard that Prince passed away without a will. And of course, he had a large estate, estimated maybe around $300 million. How much do you think the IRS received from his estate? Well, we can guess around $120 million. So the IRS is very pleased to take money from us. They appreciate that large gift. But if Prince had planned ahead of time, there are some things he could have done to minimize his estate tax burden. But after you pass away, it's too late to plan for those things, and there's nothing that can be done. Now, once the estate tax is paid to the IRS, if there are issues with that, the money goes to the kids. And now we've talked about how Rebecca and her siblings are under the age of 18, and so there's going to be another conservatorship hearing to figure out who takes care of the money. Is it going to be Mark? Is it going to be grandma? And also remember, without a will, those kids are going to get the money right at 18. So you got a bunch of 18-year-old millionaires again going crazy with the money. So clearly there's some things we could do better. Let's see what we can do better here for the Bliss family if they had a plan in place. So if Molly created a will, she could name guardians for her children. So there's going to be no arguments, no probate court, no grandma and Mark trying to figure out what's best for Rebecca. And Rebecca's not in the middle of all that. Now, she could also create a trust. And if she had a trust, she'd put her assets inside of the trust, including the beach house, so that upon her passing, she would name exactly who was to receive the beach house, and that would avoid probate. There would be no beach house stuck in the probate process, none of the probate fees associated with transferring the real estate, and it just happens immediately, so no delays. Now, Molly, because she had a plan, she did it correctly, and she created a trust, and she had her assets inside of there. So all of her money, if she had any life insurance, The homes, like we said, everything's immediately available for her family and her loved ones. No probate, no attorneys involved, smooth process. And if Molly had gone to an estate attorney first, if she did in fact owe any estate taxes, she had a plan to minimize those estate tax because she did it ahead of time. Remember, you can't do it after the fact. Estate tax planning has to be done before you pass away. And remember, after the IRS, after the taxes and everything is paid, she was able to put the money in trust for her children so that they have their assets protected during their lifetimes. So she can put the money in the trust. Remember, she can determine what ages her kids get the money, whether it's 25, 30, 50, and she determines on what schedule that money is paid out to her kids. And most importantly, who's taking care of that money? Who does she trust to take care of the money for her kids until they're of age to take care of it for themselves? We haven't talked much about pets, but you can also plan for your pets, whether that's naming a guardian, naming some money for your pets to be taken care of. But an important part of estate planning for sure, those are our fur babies. So lesson number 4 for our family is if you want control of your assets and your loved ones and what happens to them, you've got to act before it's too late. You've got to do it now. Bonus lesson, what is it really like for your loved ones after you pass away? We meet with a lot of families, of course, after they've lost loved ones as we help them administer their estates, whether their estate plan wasn't done correctly or whether they just didn't do one and they didn't have a will or trust at all. But what do the loved ones care about most? They care about missing you and grieving you. And the last thing they want to be doing is thinking about paperwork and talking to lawyers. They want to be thinking about your legacy and remembering all the good things and all the good times that they shared. Now, I want to just take you back to where you wrote down who the people are that you're actually here for today. Remember why you're here. Again, it's not for you. We don't do estate planning for ourselves. It's because of the people that we love and people we want to protect. Now, I wanted to be just a little bit upfront with all the costs. So there's costs of probate. So if you don't have a trust and your assets all go through probate, I just want to give you an idea what it costs here in North and South Carolina. So maybe your average family has their house is worth $500,000. They've got a retirement plan, 401k, around $300,000, a life insurance policy for $500,000. Sometimes we forget to include those things as the worth of our estate, but all that together totals $1.3 million. The average cost of probate here, actually across the country, but here as well, is cost 3 to 7% of the value of your estate is the cost, how much it costs to probate an estate. So 3% is $39,000, 7% is $91,000. So you're looking somewhere in there just for the cost to probate your estate, not to mention the time. As we mentioned before, average probates here are about 9 months to 2 years before your probate estate is settled. Now, if you plan ahead and you create a trust and that trust is properly funded and done properly, average cost for a trust plan here is around $4,900. And you're saving the probate fees of 3 to 7% because if you have a trust, your assets do not go through probate. So you're saving the $39,000 to $91,000, the average probate cost, by investing in the trust and investing the time and taking the time to work with us to make sure the trust is funded correctly and properly. We will not let you go without making sure that is done. Not to mention you have time savings. We can plan ahead with the trust to minimize any estate tax that you might owe. We can also help plan to minimize estate tax while preserving capital gains taxes that might be owed later. And of course, the importance of privacy. We mentioned that a will is a public document. So wills go through probate court and everybody has access to what was in your will, what your assets were. If you have a trust, nobody knows who you gave your assets to or what your assets were. Now, who is a living trust for? Do I even need one? So someone who needs a living trust is anyone who owns real estate, anyone who has assets over $75,000, or if you have any minor children or any beneficiaries that have special needs. We don't want to leave an inheritance outright to an individual with special needs because that will cause them to lose their Medicaid and SSI benefits. And if we create the trust properly, they can still have money in the trust for their benefit, but also maintain those benefits of those government benefits that they receive. Trust is great for business owners, people who own LLCs, and of course, super important, my own family included, blended families. There's a lot of conflict, a lot of things we can do with the trust to prevent some of that conflict is inherent to blended families often when a loved one passes. Now, I just want to take a minute to check in with you. How are you doing? I know it's a lot of information. It's like drinking out of a fire hose a little bit. But our intent is not to overwhelm you here, but to tell you a little bit about We Gotcha and how our planning process works. Now, it's kind of a three-step. The first step is, you would receive a questionnaire you'd fill out, and that helps us make the most efficient use of our time together. We would meet. After we meet, we would draft your documents, which would take a couple of weeks. And then you come in, you sign those documents. And then a couple of weeks after that, we'd have another follow-up meeting to make sure that your trust is funded correctly. So it's about 4 to 6 weeks in total from the beginning to the end. And we hold your hand every step of the way. We try not to make it scary. Also, I didn't mention here, but with all of our clients, if anyone creates a plan with us, you're also going to receive a call from us or an email from us in 3 years after the date of your signing. And we're just going to offer to sit down with you again for free. We're going to go over your plan, make sure it's still working the way you need it, make sure there's not any big changes in your family that we need to address in the documents, and also update you if there's any big changes in the law that need to be considered in creating an estate plan that will work for you. When you come in to meet with us, you'll meet with one of our 5 experienced estate attorneys. Now, it's important, I really stress this, that even if you don't use us, you talk to a lawyer that only practices estate law. It's a very complex area of the law, and there's a lot to learn in it. We don't advise that you go to a lawyer that maybe practices divorces on Mondays and DUIs on Tuesdays and wills on Wednesdays. You want to meet with someone that this is the only area of law that we practice. And that is true here at Simpson Law. It's all we do. We've assisted a lot of families over the years in getting estate plans in place. And we know a lot about the pitfalls of planning just because we also do a lot of estate administration here for families that either didn't get an estate plan done or had a trust but never got it funded or didn't have a will. We administer a lot of estates through the probate court, so we really have a good idea of the pitfalls that you can avoid by doing proper planning. And importantly, we take it as a compliment when people tell us we're too nice to be lawyers. I used to get that compliment and think maybe it wasn't a compliment, but now I take it as a compliment. We really do treat every person with respect and care here. And as our thank you for watching this webinar today, we're going to give you that first meeting with the attorney is going to be complimentary, which is a $750 value. It's your golden ticket. So that will be a 1.5 hour planning meeting with one of our 5 attorneys. And during that meeting, we'll talk about all of your assets, your family. We'll get to know your situation and let you know what would happen with your current plan in place if you've got one, or if you don't have one, what would happen to your family without a plan in place. And we will also design a comprehensive plan for your family so that it will work the way that you want it in the time that your family needs it the most. And that is our thank you to you today for attending this webinar and watching. So $750 value because it's about 1.5 hours to 2 hours worth of our attorney's time. That's our gift to you. Now, traditionally, when you go to another estate firm, you got hourly fees, one-off transactions you may not even finish. We get a lot of people come here that they never even signed their wills. And if they did finish, they have this expensive stack of documents that may not work because they never funded their trust. Those things don't happen here. We have flat fees, so no hourly fees. We make sure your documents are signed with our witnesses and notaries here at the office. And we make sure that your trust is funded correctly, and we followed up with you to make sure all the beneficiaries are done correctly and that your assets are titled correctly. And it's our promise that when your estate plan's done, we'll cover everything you need for peace of mind. So you know your plan will work for your family when you need it most. Now, how do you take advantage of meeting for free with one of our attorneys to find out a plan that's right for you? Lots of ways. You can call our number here on the screen. You can email us at info@simpsonestatelaw.com. You could also go directly to our website, simpsonestatelaw.com. And you can book an appointment there directly. We have 2 offices. We have our Fort Mill office, and I apologize it's not on the screen, but we just opened up our other office, which is our Charlotte, Indian Land office. So whichever one is most convenient to your location. We also can conduct initial calls by Zoom. Just really try to make it the easiest as possible for you to get your plan done. Really appreciate your time today. If you have a spouse or significant other, I'd really encourage them to watch this webinar as well. And please bring your list of questions with you that you wrote down as we were talking today, and the attorneys will be more than happy to answer those for you. And thank you for hanging in there to the end of this. Appreciate it, and we look forward to meeting you.